Welcome to Ask the Lawyer, International Edition, the radio show that brings you the latest trends in immigrating to the United States. Hosted by attorney Brian Figueroa of the law firm Figueroa and Associates. This program is designed to provide valuable insights for those who wish to live, work, study, or invest in the U.S. Whether you're an international student seeking educational opportunities, an entertainer looking to break into the U.S. market, or a business owner wanting to expand your operations and tap into the vast U.S. economy, this show is for you. If you're an investor exploring options in the U.S. or someone with family or friends already living here, you won't want to miss the important information shared on Ask the Lawyer, International Edition. Each week, we dive into critical topics that help you navigate the complexities of U.S. immigration and business law. Special guests include experts in business development, elected officials supportive of immigration, business owners, and nonprofit leaders who provide real-world advice and guidance for those wanting to build a future in the U.S. The law firm of Figueroa and Associates was founded not only to serve our clients, but to contribute to the greater good. We understand the importance of helping individuals and businesses achieve their American dreams, and we are committed to providing the legal expertise and support needed to make that happen. So whether you're an entrepreneur looking to open a branch of your business in the U.S., an investor ready to explore opportunities, or someone hoping to migrate and build a new life in America, you should tune in and learn from this informative program. Ask the Lawyer. International Edition is your resource for understanding U.S. immigration trends, business opportunities, and legal strategies. Call now. For personalized legal advice, contact the experienced attorneys at Figueroa and Associates today. Our team is here to help you navigate the path to success in the U.S. Thank you for listening to Ask the Lawyer, International Edition with attorney Brian Figueroa. Visit us online at askthelawyer.us or call today to schedule your consultation.
Good day, good day, good day. My name is Brian Figueroa of the law firm Figueroa and Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. If you are in Jamaica, if you're in Trinidad and Tobago, the U.S. market is a great market for businesses in those countries to start a branch of their business in the United States. It's called the E2 Treaty Visa. If you don't know anything about it, visit our website and we have essays on what an E2 Treaty Visa is and how you could start a branch of your business in the United States of America. We could assist you with those applications. There are already businesses from TNT, from Jamaica, that have already taken advantage of the E2 Treaty arrangement. This is an arrangement through bilateral relationships between those countries and the United States of America. Grenada is another country that is an E2 Treaty country. I am hoping that other countries in the Caribbean, whether it be St. Vincent, St. Lucia, Guyana, that they will build this relationship also to extend their businesses, their successes in the Caribbean into the U.S. It is not a work visa, it's a business visa. My name is Brian Figueroa of the law firm Figueroa and Associates. This is Ask the Lawyer, our international edition in the Caribbean. We also urge people who want to study in the United States to get their F1 visa, their student visa. People who want to become visitors to the United States of America. Don't just go to the consulate, apply for your visitor's visa, and have it rejected. We will help you in the process so that you prepare those forms properly. And obviously, preparation is always important. So whether it be a student visa, a visitor's visa, talk to us. When you are in the U.S., obviously, if you want to extend your vacation without violating your visitor's visa, we could also work with you if an extension is necessary. The U.S. market, the U.S. in terms of tourism, whether it be Disney World in Florida, whether people want to come to the great New York City, where our law firm is located in Brooklyn, New York. People make these trips all the time, and obviously, it's part of obviously people come here to shop, people come here to look at schools, in terms of their children or themselves, and then later on, they may want to get that student visa, as we spoke about. Even business owners could come and scope out the market here as to whether or not their business could be successful. One of the larger companies here that already have a presence is Barron's Pepper Sauce. They have like factories, I believe, throughout at least 3 or 4 Caribbean countries. Their products are at the various supermarkets and Chinese corner stores that sell their products along with other products. So, those of you who are listening and you want to get your foot in the door, you are a manufacturer. How do you get your product into the U.S. market? These are issues that we address on Ask the Lawyer each and every week. Again, my name is Brian Figueroa of the law firm Figueroa and Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. To schedule a consultation, go to our website, the law firm of Figueroa and Associates, at www.askthelawyer.us. Again, www.askthelawyer.us. Another visa that you might be interested in as a business person is what we call the EB-5 visa, i.e., that EB-5 leads to a green card. If you invest in the U.S. in a business, either a direct investor or through a regional center, the investor's spouse, and all the investors' children that are below 21 years old will qualify to get a green card. That investment requires that 10 Americans get jobs because of your investment. As I said, it could be a direct investment where you actually start a business or partner with another business in the U.S., or you invest in what we call a regional center, which normally invests your money in real estate development. Obviously, you have to be careful about your investment. You do not want to lose that $500,000 or $1 million that you invested in some bad deal, so to speak. So we will help you not only with the application process, but making a decision as to what is the best fit for you. Again, my name is Brian Figueroa of the law firm Figueroa and Associates. This is Ask the Lawyer. You got questions, we got answers. The EB-5 investment is normally an investment vehicle used a lot by people in China and in Hong Kong. It was instituted when Hong Kong was going to back to China, and England and the U.S. wanted to get those rich Chinese in Hong Kong that may not have liked communism. Thank you.
Are you planning a trip to the United States but unsure how to navigate the visa process? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys will guide you step by step through the visitor's visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand in the way of your dream vacation. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless clients like you successfully secure their U.S. visas. Let us take the stress out of the process so you can focus on planning your perfect trip. Are you looking to study in the United States but confused about how to apply for a student visa? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in guiding students through the visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand between you and your academic dreams in the U.S. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless students secure their student visas and begin their educational journey in the United States. Let us help you make your study abroad dream a reality. Figaro and Associates, your trusted partner in student visa success. Are you a professional in the U.S. looking to apply for an H-1B visa? The process can be complicated, but the law firm of Figaro and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys can guide you through every step, from employer petitions to USCIS filings, ensuring your H-1B application is handled with care. Schedule a consultation today at www.askthelawyer.us or call us at 855-768-8845. Let Figaro and Associates help you secure your future in the U.S.
Do you have a family member overseas that you want to bring to the United States? The law firm of Figaro and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in family-based green card petitions, guiding you step by step through the process to reunite you with your loved ones. Whether you are a U.S. citizen or a green card holder, we will ensure your petition is handled smoothly and efficiently. Plus, we can help you understand how filing for a green card may impact your relative's visitor visa. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845 to discuss your case with our skilled legal team. Are you a lawyer with a degree from the Caribbean who dreams of practicing law in New York? The path to becoming licensed in the U.S. can be challenging, but Figaro and Associates is here to help. Located in Brooklyn, New York, our team specializes in guiding foreign-trained lawyers through the bar admission process. From prudential evaluation and additional legal education to bar exam preparation and fulfilling pro bono requirements, we're with you every step of the way. Let us help you turn your ambition into reality. Visit us at www.askthelawyer.us or call 855-768-8845 to schedule a consultation. Don't let the complexities of the U.S. legal system hold you back. Contact Figaro and Associates today.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father,
U.S.
Brian
immigration
Figueroa.
law provides a pathway for U.S. citizens to petition for their foreign-born spouses to adjust their immigration status and obtain lawful permanent residency, commonly known as a green card. However, this process can become more complex when the foreign spouse has entered the U.S. on a temporary visitor visa, such as a B-2 tourist visa, and has overstayed the time allowed on their I-94, the arrival/departure record issued by U.S. Customs and Border Protection, CBP. While overstaying a visa can lead to various legal complications, there is still a pathway to adjust status to a green card for spouses of U.S. citizens, even for those who have overstayed their visa. This article will provide a detailed analysis of the process for a U.S. citizen to simultaneously petition for and adjust the status of their spouse who has overstayed their visitor visa. It will cover all the steps involved, from filing the necessary forms to attending interviews, as well as highlighting potential challenges and the importance of seeking legal assistance. Overstay and the immediate relative exemption. U.S. immigration law is strict when it comes to visa overstays. A visa overstay means that the individual remained in the country beyond the expiration date on their I-94 form, which tracks the duration of their permitted stay. Overstaying a visa typically renders an individual out of status and may subject them to penalties, including a ban on re-entering the U.S. However, there is a crucial exception for individuals who are immediate relatives of U.S. citizens, including spouses.
The U.S. government allows spouses of U.S. citizens to adjust their immigration status even if they have overstayed their visa, as long as they entered the country legally with inspection and admission at a port of entry. This means that the foreign spouse can apply for a green card without leaving the U.S., despite their overstay. This is a significant benefit because leaving the U.S. after overstaying a visa could trigger a 3 or 10-year re-entry bar, depending on how long they were unlawfully present. Simultaneous petition and adjustment of status. When the U.S. citizen spouse wants to help their foreign-born spouse who has overstayed their visa obtain a green card, they can take advantage of the process known as concurrent filing. This means that the U.S. citizen spouse can submit a petition, Form I-130, for their foreign spouse at the same time that the foreign spouse files their adjustment of status application, Form I-485. Concurrent filing can significantly expedite the process, as it eliminates the waiting period between the approval of the petition and the adjustment of status application. Here is a step-by-step breakdown of the process. Step 1. Filing Form I-130, Petition for Alien Relative. The first step in the process is for the U.S. citizen spouse to file Form I-130, the Petition for Alien Relative. This form is used to establish the existence of a valid relationship between the U.S. citizen and the foreign-born spouse. Essentially, it is a request for the U.S. Citizenship and Immigration Services, USCIS, to recognize that the marriage is legitimate and should entitle the foreign spouse to apply for a green card. Required documentation for I-130. Proof of U.S. citizenship of the petitioner, U.S. citizen spouse, such as a U.S. passport, birth certificate, or naturalization certificate. Evidence of a bona fide marriage, including a marriage certificate, joint financial documents, such as bank account statements or lease agreements, photos of the couple together, and affidavits from friends and family confirming the legitimacy of the relationship. Proof of termination of any previous marriages, if applicable, such as divorce decrees or death certificates. The filing fee for Form I-130, currently $535. Step 2. Filing Form I-485, Application to Adjust Status. At the same time that Form I-130 is submitted, the foreign-born spouse can file Form I-485, Application to Register Permanent Residence or Adjust Status. This form is used to apply for a green card and is submitted directly to USCIS. Required documentation for I-485. Completed Form I-485. Copy of the I-94 arrival/departure record showing legal entry into the U.S. 2 passport-sized photos of the foreign-born spouse. Medical examination and vaccination records, Form I-693, completed by a USCIS-designated civil surgeon. Copy of the marriage certificate. Affidavit of support, Form I-864, from the U.S. citizen spouse, which is required to demonstrate that the petitioner can financially support their foreign-born spouse and prevent them from becoming a public charge. The filing fee for Form I-485, currently $1,225, including biometrics. By filing both forms simultaneously, the couple initiates the petition and the adjustment of status process at the same time, reducing the overall waiting period. Step 3. Form I-765, Application for Employment Authorization, and Form I-131, Application for Advance Parole. Along with Form I-485, the foreign-born spouse can also submit Form I-765, Application for Employment Authorization, which allows them to work legally in the U.S. while the green card application is pending. Form I-131, Application for Travel Document, Advance Parole, which allows them to travel outside the U.S. and return without abandoning their adjustment of status application. These applications are optional, but can be highly beneficial, especially since the processing times for the green card application can be lengthy. Step 4. Biometrics appointment. After submitting the necessary forms, USCIS will schedule a biometrics appointment for the foreign-born spouse. During this appointment, USCIS will take their fingerprints, photograph, and signature, which will be used to run a background check and verify their identity. The appointment is typically brief and is a routine part of the green card process. Step 5. USCIS interview. After processing the I-130 and I-485 forms, USCIS will schedule an interview for the couple. Both spouses are required to attend this interview, which takes place at a local USCIS office. The interview's primary purpose is to determine the legitimacy of the marriage and to ensure that it is not fraudulent or solely for immigration benefits. During the interview, the USCIS officer may ask questions about how the couple met, the details of their wedding, their living arrangements, shared responsibilities, for example, finances, children, household duties, future plans together. It is essential that the couple prepares for this interview and brings all relevant documentation to support their relationship, such as joint bank statements, lease agreements, photos, and any other evidence that proves the marriage is genuine. Step 6. Approval of green card. If USCIS is satisfied with the legitimacy of the marriage and all other aspects of the application are in order, they will approve the foreign-born spouse's adjustment of status application, and the foreign spouse will receive a green card. Conditional green card for marriages less than 2 years. If the couple has been married for less than 2 years at the time the green card is issued, the foreign-born spouse will receive a conditional green card that is valid for 2 years. To remove the conditions on the green card and obtain a permanent 10-year green card, the couple must file Form I-751, petition to remove conditions on residence, within the 90-day period before the conditional green card expires. Challenges and legal risks. While the process may appear straightforward, there are several risks and challenges that could arise, particularly in cases involving visa overstays. These include public charge concerns. USCIS may deny the green card application if they believe the foreign spouse is likely to become a public charge, meaning they may rely on government benefits. The affidavit of support, Form I-864, is crucial in addressing this issue, as it demonstrates that the U.S. citizen spouse has sufficient income to support the foreign spouse. Misrepresentation or fraud concerns. If the foreign spouse entered the U.S. on a visitor visa with the intention of staying permanently, USCIS may accuse them of visa fraud. This is a serious concern, as misrepresentation at the time of entry could result in the denial of the adjustment of status application. It is important to provide evidence that the overstay was unintentional and that the foreign spouse did not plan to remain in the U.S. permanently when they entered on a temporary visa. Unlawful presence. Leaving the U.S. during the adjustment of status process without an approved travel document, advance parole can trigger the 3 or 10-year bar on re-entry if the foreign spouse overstayed their visa. To avoid this, the foreign spouse should not leave the U.S. until they receive advance parole or their green card. Why legal assistance is essential. Navigating the immigration process is complicated, especially when visa overstays are involved. There are numerous forms to file, deadlines to meet, and documentation to provide. Even a small mistake can result in delays, denials, or, in the worst-case scenario, removal proceedings. This is why legal representation is highly recommended. An experienced immigration attorney can guide couples through the process, ensuring that all forms are properly completed, that deadlines are met, and that the necessary evidence is provided. An attorney can also help couples prepare for their USCIS interview and handle any complications that arise during the process, such as requests for additional evidence, RFEs, or issues related to the overstay. Why legal assistance is essential. Navigating the immigration process is complicated, especially when visa overstays are involved. There are numerous forms to file, deadlines to meet, and documentation to provide. Even a small mistake can result in delays, denials, or, in the worst-case scenario, removal proceedings. This is why legal representation is highly recommended. An experienced immigration attorney can guide couples through the process, ensuring that all forms are properly completed, that deadlines are met, and that the necessary evidence is provided. An attorney can also help couples prepare for their USCIS interview and handle any complications that arise during the process, such as requests for additional evidence, RFEs, or issues related to the overstay. For married couples in which one spouse has overstayed their visitor visa in the U.S., the path to a green card is possible but requires careful navigation. Concurrent filing of Form I-130 and Form I-485 allows the foreign spouse to adjust their status without leaving the U.S., even if they have overstayed their visa. While the process offers significant advantages, it also comes with potential risks, making it critical to seek legal assistance. If you are in this situation, seeking the help of a qualified immigration attorney is essential to ensuring a smooth and successful outcome. Legal representation can make the difference between a swift resolution and a prolonged, stressful immigration ordeal. The law firm of Figueroa and Associates, which has over 25 years practicing immigration law, can help you navigate the process and avoid common pitfalls. To schedule an appointment, visit www.askthelawyer.us or call 855-768-8845. The lawyer you hired does make a difference.
If your spouse has overstayed their visa and you want to help them obtain a green card, we can help. The process of adjusting status can be complex, especially if there was an overstay, but the law firm of Figueroa and Associates, located in Brooklyn, New York, has the experience and expertise to guide you through it. Our team of immigration lawyers will assist you every step of the way, from filing petitions to representing you at interviews. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Get the right legal help when it matters most.
Are you a professional living overseas and dreaming of working in the United States? The H-1B visa is your gateway to achieving that goal, but the process can be complicated. That's where the law firm of Figueroa and Associates comes in. Located in Brooklyn, New York, we specialize in immigration law and can guide you every step of the way. From securing employer sponsorship to navigating consular interviews, let us help you turn your dream into reality. Visit us at www.askthelawyer.us or call 855-768-8845 to schedule a consultation today. At Figueroa and Associates, we're here to make the immigration process smoother, faster, and easier for you. Don't wait. Your future in the U.S. starts now. Are you visiting the U.S. and need to extend your stay due to an extended vacation or an emergency? The process can be complicated, but the law firm of Figueroa and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys can assist you in filing for an extension of your stay, ensuring all paperwork is handled properly and on time. Schedule a consultation today at www.askthelawyer.us or call us at 855-768-8845. Let Figueroa and Associates guide you through the process with confidence. Starting a business in New York City, choosing the right business structure is critical to your success. The law firm of Figueroa and Associates, located in Brooklyn, New York, can guide you through the process, from mults and corporations to partnerships and sole proprietorships. We help you navigate the legal complexities to protect your interests. Schedule a consultation today at www.askthelawyer.us or call 855-768-8845. Let Figueroa and Associates help you build a solid foundation for your business.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
Visiting the United States is a dream for many around the world. Whether you want to explore iconic landmarks like the Statue of Liberty, experience American culture, or visit friends and family, the first step is securing a U.S. visitor's visa, known as a B-2 visa. The process can seem daunting, especially for someone living overseas. However, with proper preparation and understanding of the process, it's possible to navigate it successfully. This article will provide a step-by-step guide on how to apply for a U.S. visitor's visa from overseas, along with tips to improve your chances of approval. Understanding the U.S. visitor's visa B-2. The B-2 visa is intended for those who wish to enter the United States temporarily for tourism, vacation, or medical treatment. It's classified as a non-immigrant visa, meaning you are expected to return to your home country after your stay in the U.S. B-2 visa holders are permitted to visit tourist attractions, national parks, and other landmarks, Attend cultural or sporting events. Visit family or friends. Receive medical treatment. Participate in short recreational courses, as long as it's not for credit toward a degree. It's important to note that working, studying, or living permanently in the U.S. is not allowed under the B2 visa. Step-by-step application process for a U.S. visitor's visa. Step 1. Determine your visa type. Before beginning the application, it's important to ensure that a B2 visa is the right one for your intended purpose. If you plan to travel to the U.S. for tourism, visiting family, or medical treatment, the B2 visa is likely appropriate. Step 2. Complete the DS-160 form. The DS-160 form is the online non-immigrant visa application form, which is mandatory for all visitor visa applicants. The form collects information about your personal details, travel plans, and background. Where to apply? Visit the Consular Electronic Application Center (CEAC) website to fill out the form. Documents you need: passport details, travel itinerary, and dates of your 5 previous visits to the U.S., if applicable. You'll also need a digital photo that meets specific requirements, including size and quality. Accuracy is key. Make sure every detail is accurate and honest. Any discrepancies could lead to delays or denial of your visa application. Step 3. Pay the visa application fee. After completing the DS-160 form, you'll need to pay a non-refundable application fee. As of 2024, the fee for a B2 visa is $185 USD, but it's advisable to check the official U.S. Department of State website for the most current fee structure. How to pay? Payment methods vary by country, but most consulates allow online payment through a credit card, bank transfer, or local payment systems. Save the receipt. Once payment is made, save the receipt as it will be required during your visa interview. Step 4. Schedule your visa interview. After paying the visa fee, you must schedule an appointment for a visa interview at the U.S. Embassy or consulate in your country. The wait time for an appointment can vary by location, so it's recommended to book as early as possible, especially during peak travel seasons. Where to schedule? Visit the U.S. Embassy or consulate website in your country to schedule the interview. Some locations may allow scheduling by phone or online. Wait times. In certain countries, the waiting time can range from days to months. It's wise to check the consulate's website for current wait times and plan accordingly. Step 5. Prepare for your interview. The visa interview is a critical step in the application process, as the consular officer will determine whether you qualify for a visitor's visa. Documents to bring: a valid passport, the DS-160 confirmation page with the barcode, proof of visa fee payment, your appointment confirmation letter, a passport-sized photo if your photo upload failed on the DS-160, financial documents proving you can afford the trip and will not need public assistance in the U.S., evidence of ties to your home country, job contracts, property ownership, family ties, to show that you intend to return after your visit. Any relevant travel plans, such as hotel bookings or invitations from family or friends in the U.S. Interview questions to expect. During the interview, be prepared to answer questions about your reasons for visiting the U.S., how long you intend to stay, and your financial means to support your trip. It's essential to convey that your visit is temporary and that you have no intention of overstaying your visa. Step 6. Attend your interview. Arrive on time for your visa interview, dress neatly, and bring all required documentation. The interview typically lasts between 5 and 15 minutes. The consular officer will ask you questions to assess your eligibility for a visitor's visa. Common questions: why do you want to visit the U.S.? How long will you stay? Do you have family or friends in the U.S.? What do you do for a living? Be honest. Answer all questions truthfully. Any signs of dishonesty or inconsistencies can lead to your visa being denied. Possible outcomes. After the interview, the officer will inform you whether your visa is approved or denied. If approved, you will be informed of when and how you will receive your visa. In some cases, additional administrative processing might be required, which can extend the decision-making period. Step 7. Visa approval and travel. If your visa is approved, it will be placed in your passport, and you can use it to travel to the U.S. It's important to note that a visa does not guarantee entry into the U.S. The Customs and Border Protection (CBP) officer at the port of entry has the authority to admit or deny your entry. Tips for a successful visa application. Applying for a U.S. visitor's visa can be complicated, but following these tips can improve your chances of approval. Provide strong evidence of ties to your home country. Consular officers want to be assured that you will return to your home country after your visit. Be prepared to present proof of employment, property ownership, family responsibilities, or other factors that demonstrate your intention to return. Have a clear travel plan. You should have a well-organized itinerary for your trip. If possible, provide hotel reservations, tour bookings, and details of the places you plan to visit. Financial readiness. Demonstrate that you have sufficient funds for your trip. Bank statements or financial documents can help prove that you can afford your stay in the U.S. Be honest and consistent. During your interview, answer all questions truthfully and consistently. Any signs of deception or discrepancies between your answers and the information on your DS-160 form could lead to a visa denial. What to do if your visa is denied? Visa denial can be disappointing, but it's not the end of the road. If your visa application is denied, the consular officer will give you a reason for the denial. The most common reasons for denial are inadequate proof of ties to your home country, inconsistent or incomplete documentation, concerns about your financial stability. If denied, you can reapply by addressing the issues that led to the rejection. However, you will need to pay the visa application fee again. Applying for a U.S. visitor's visa from overseas can be a complex process, but careful preparation and adherence to the guidelines can greatly improve your chances of success. Ensure that your documentation is accurate, your ties to your home country are well documented, and you are honest throughout the process. Once your visa is granted, you'll be able to enjoy your trip to the U.S. with peace of mind. If you need legal assistance with your visitor's visa application, it is important to consult with an experienced attorney. The law firm of Figaro and Associates, which has over 25 years practicing immigration law, and can help you navigate the process and avoid common pitfalls. To schedule an appointment, visit www.askthelawyer.us or call 855-768-8845. The lawyer you hired does make a difference.
Are you planning a trip to the United States but unsure how to navigate the visa process? The law firm of Figaro and Associates located in Brooklyn, New York is here to help. Our experienced immigration attorneys will guide you step by step through the visitor's visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand in the way of your dream vacation. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless clients like you successfully secure their U.S. visas. Let us take the stress out of the process so you can focus on planning your perfect trip. Are you looking to study in the United States but confused about how to apply for a student visa? The law firm of Figaro and Associates located in Brooklyn, New York is here to help. Our experienced immigration attorneys specialize in guiding students through the visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand between you and your academic dreams in the U.S. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless students secure their student visas and begin their educational journey in the United States. Let us help you make your study abroad dream a reality. Figaro and Associates, your trusted partner in student visa success.
Do you have a family member overseas that you want to bring to the United States? The law firm of Figaro and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in family-based green card petitions, guiding you step by step through the process to reunite you with your loved ones. Whether you are a U.S. citizen or a green card holder, we will ensure your petition is handled smoothly and efficiently. Plus, we can help you understand how filing for a green card may impact your relative's visitor visa. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845 to discuss your case with our skilled legal team. Are you a lawyer with a degree from the Caribbean who dreams of practicing law in New York? The path to becoming licensed in the U.S. can be challenging, but Figaro and Associates is here to help. Located in Brooklyn, New York, our team specializes in guiding foreign-trained lawyers through the bar admission process. From prudential evaluation and additional legal education to bar exam preparation and fulfilling pro bono requirements, we're with you every step of the way. Let us help you turn your ambition into reality. Visit us at www.askthelawyer.us or call 855-768-8845 to schedule a consultation. Don't let the complexities of the U.S. legal system hold you back. Contact Figaro and Associates today.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
One of the most common pathways to obtaining permanent residency, commonly known as a green card in the United States, is through family-based immigration. U.S. citizens and lawful permanent residents, green card holders, can petition for certain family members living overseas to join them in the U.S. and apply for permanent residency. This process is known as family-based immigration, and it requires several steps that must be carefully followed to ensure success. In this article, we will break down the process for someone living overseas to have a U.S. citizen or green card holder family member petition for their green card. We will also explore how this process might impact any existing U.S. visitor visas, what to expect in terms of timelines, and potential challenges that may arise. Overview of family-based immigration. Family-based immigration allows U.S. citizens and lawful permanent residents, LPRs, to sponsor certain relatives to immigrate to the United States. The process involves filing a petition, going through consular processing for family members overseas, and ultimately obtaining a green card. Categories of family members eligible for sponsorship. That eligibility to sponsor a family member for a green card depends on the petitioner's status, whether they are a U.S. citizen or green card holder, and the relationship to the relative. For U.S. citizens, they can sponsor immediate relatives, which include spouses, parents, if the petitioner is over 21, and unmarried children under 21 years old. These categories are not subject to visa quotas, which means there is no waiting period once the petition is approved. Other family members, including unmarried sons and daughters over 21, married children of any age, siblings, if the petitioner is over 21. For green card holders, lawful permanent residents, they can sponsor spouses. Unmarried children regardless of age. Green card holders cannot sponsor married children or siblings. Preference categories and visa availability. Family-based immigration for relatives outside the immediate relatives category is subject to visa availability under the preference category system. Immediate relatives of U.S. citizens are not subject to numerical limits, but other family categories like siblings of U.S. citizens or spouses of green card holders are subject to annual limits, which can create long waiting times depending on the relationship and the petitioner's country of origin. First preference, F1, unmarried adult children over 21 of U.S. citizens. Second preference, F2A and F2B, spouses and children of green card holders, F2A, and unmarried adult children over 21 of green card holders, F2B. Third preference, F3. Married children of U.S. citizens. Fourth preference, F4. Siblings of U.S. citizens. Once the petition is approved and the visa becomes available for the relative, the process moves forward to consular processing or adjustment of status if they are already in the U.S. Step-by-step process for family-based green card petition for overseas relatives. Step 1. Filing Form I-130, Petition for Alien Relative. The process begins when the U.S. citizen or green card holder files a Form I-130, Petition for Alien Relative with U.S. Citizenship and Immigration Services, USCIS. This form establishes the family relationship between the petitioner, U.S. citizen or green card holder, and the beneficiary, the relative living overseas. Supporting documents. The petitioner will need to submit supporting documents proving their relationship with the beneficiary. This may include birth certificates, marriage certificates, or proof of adoption, depending on the relationship. Filing fee. As of 2024, the filing fee for Form I-130 is $535, but it's advisable to check the USCIS website for current fees. Once USCIS receives the I-130 petition, they will review it and either approve or deny the application. Processing times can vary, but it generally takes several months for USCIS to adjudicate the I-130 petition. Step 2. Wait for approval and visa availability. If the I-130 petition is approved, the next step depends on the family member's category. Immediate relatives, spouses, parents, unmarried children under 21 of U.S. citizens. These applicants can proceed directly to the next steps, as visas are immediately available. Preference categories. A. Adult children, siblings. For relatives who fall under preference categories, the approved petition enters the visa queue. Because of annual visa caps, applicants may have to wait for their priority date, the date the I-130 petition was filed, to become current based on the Visa Bulletin, which is updated monthly by the U.S. Department of State. Step 3. Consular processing for overseas relatives. Once the visa is available, overseas applicants go through consular processing. This involves the following steps. National Visa Center, NVC processing. After USCIS approves the petition and the visa becomes available, the case is transferred to the National Visa Center, NVC, which collects fees and documentation to prepare for the visa interview. Complete Form DS-260. The beneficiary, overseas family member, must complete Form DS-260, which is the online immigrant visa application. This form asks for detailed personal information, including background, employment history, and travel history. Submit supporting documents. The NVC will also require submission of supporting documents such as police clearance certificates, medical exams, financial support affidavits, and civil documents like birth certificates and marriage certificates. Pay visa fees. Fees for the immigrant visa application, affidavit of support processing, and medical exam must be paid during this stage. As of 2024, the total cost of consular processing can range from $300 to $400, depending on various factors. Step 4. Attend the visa interview at the U.S. consulate. Once all documents are submitted and processed, the applicant will be scheduled for a visa interview at the U.S. embassy or consulate in their home country. During this interview, a consular officer will ask questions to verify the relationship, ensure that the applicant is eligible for immigration, and assess the legitimacy of the application. Bring required documents. The applicant must bring all required documents to the interview, including their passport, photos, medical exam results, and financial support documentation. Outcome. If approved, the beneficiary will receive an immigrant visa and their passport, which allows them to travel to the U.S. as a lawful permanent resident. Step 5. Enter the U.S. and receive the green card. Upon entering the U.S. with the immigrant visa, the beneficiary will be processed by Customs and Border Protection, CBP, at the port of entry. They will receive a stamp in their passport, which serves as proof of lawful permanent resident status, green card, until the official green card arrives by mail. Impact of family-based green card petition on a visitor visa. Many individuals who have a visitor visa B1/B2 to the U.S. may wonder how filing for a green card through a family member might affect their current visa status. Here are a few key points to consider. Dual intent. A visitor visa is intended for short-term stays for purposes like tourism, medical treatment, or business. The visa does not allow the holder to remain in the U.S. permanently. Filing a family-based green card petition could raise concerns about immigrant intent, as applying for a green card indicates a desire to stay in the U.S. permanently. This can potentially lead to challenges if the individual tries to enter the U.S. on a visitor visa while their green card application is pending. Visa denial or revocation. If a visitor visa holder applies for a green card, their visitor visa may be scrutinized more closely. In some cases, visa officers at U.S. embassies or consulates could deny or revoke the visitor visa, particularly if they believe the individual intends to overstay their visa while waiting for their green card. Honesty at the border. If someone holding a visitor visa tries to enter the U.S. while they have a green card petition pending, they should be prepared to explain their intentions honestly to U.S. border officials. Misrepresenting their intentions can lead to a visa being canceled or even a ban from entering the U.S. In summary, filing for a green card through a family-based petition can affect a person's visitor visa. It's essential to consult an immigration attorney before traveling on a visitor visa during the green card application process. The family-based green card process for relatives living overseas involves multiple steps, from filing the initial I-130 petition to attending a consular interview and entering the U.S. as a lawful permanent resident. For U.S. citizens and green card holders, this process is a way to reunite with family members in the United States, but it requires careful preparation and attention to legal details. Furthermore, it's important to understand the potential impact of filing a green card petition on an existing visitor visa. Navigating these complexities can be challenging, so working with an experienced immigration attorney can be essential in ensuring a smooth process. The law firm of Figueroa and Associates, which has over 25 years practicing immigration law, can help you navigate the process and avoid common pitfalls. To schedule an appointment, visit www.askthelawyer.us or call 855-768-8845.
The
lawyer you hire does make
the visa process. The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys will guide you step by step through the visitor's visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand in the way of your dream vacation. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless clients like you successfully secure their U.S. visas. Let us take the stress out of the process so you can focus on planning your perfect trip. Are you looking to study in the United States but confused about how to apply for a student visa? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in guiding students through the visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand between you and your academic dreams in the U.S. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless students secure their student visas and begin their educational journey in the United States. Let us help you make your study abroad dream a reality. Figueroa and Associates, your trusted partner in student visa success.
Do you have a family member overseas that you want to bring to the United States? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in family-based green card petitions, guiding you step by step through the process to reunite you with your loved ones. Whether you are a U.S. citizen or a green card holder, we will ensure your petition is handled smoothly and efficiently. Plus, we can help you understand how filing for a green card may impact your relative's visitor visa. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845 to discuss your case with our skilled legal team.
Thank you for listening to Ask the Lawyer International Edition with attorney Brian Figueroa of the law firm Figueroa and Associates in New York. We hope you enjoyed the show, which featured immigration visitors visa, starting and doing business in New York, entertainment and business visas, religious visas, and much more. Whether you are outside the U.S. or have family in New York, the number to call, share, and keep is 855-768-8845. That's 855-768-8845. Please schedule a consultation with us at www.askthelawyer.us. That's www.askthelawyer.us. This is Ask the Lawyer, International Edition. You have questions? We've got the answers.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.